During jury selection, a potential juror asked me a question. Mr. Oginski, is there available insurance so that if we find that the doctor caused your client harm, that now the money is coming out of the insurance company rather than the doctor's own pocket? Would you like to learn what I have to answer this particular potential juror when they ask this question? Come join me as I share with you this remarkable information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury trial lawyer practicing law in the state of New York. Today I'm coming to you from Sanibel Island, Florida, and I have a few minutes to share with you this great information. So now, during the course of jury selection, we are not permitted to let the jury know whether there is or isn't available insurance. And here's the reasoning behind that. The jury is supposed to evaluate who's right and who's wrong. They are supposed to determine whether we are more likely right than wrong in the claims that we are bringing. And now, the jury is not to consider whether there is or isn't any available insurance. The defense is clearly concerned about this issue, because if the jury now recognizes that there is available insurance on behalf of the doctor, they are much more likely to give compensation to my injured client, rather than if they learn that the doctor doesn't have any insurance, and now any money that they give to the injured victim will have to come directly out of his own pocket. One of the things that we tell the jury is that they are not to consider whether there is or isn't any available insurance, and by law, we are prohibited from disclosing that information, and they're not to consider that at all in their verdict. Instead, they are only to consider whether or not we have shown that we are more likely right than wrong, and whether that wrongdoing caused injury to my client, and if so, they are then required to compensate my client for all the harms and losses he or she has suffered as a result of the wrongdoing by this doctor or hospital. That is the answer that we are required to give to the jury. There are many people who come into court who recognize that doctors and hospitals carry medical malpractice insurance. But during the course of jury selection, we are not permitted at all to have any discussion whatsoever about whether the doctor or hospital does in fact truly have insurance to cover any verdict in regard to this particular case. So why do I share this great information with you? I share it with you to give you an insight and an understanding to what goes on in the jury selection process in a medical malpractice case here in the state of New York. Well, it's not here, I'm actually in Sanibel, but in cases in New York. And you know, I realize you're watching this because you have questions or concerns about your own particular matter. Well, if your matter happened in New York and you do have legal questions, what I encourage you to do is pick up the phone and call me. I can answer your legal questions. You know, I do this every single day and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, G-E-R-R-Y, at oginski-law.com. That's it for today's quick video. I'm Gerry Oginski. Have a wonderful day.